back pages of the amended summons, it appeared that the self-represented litigant did not consent to accepting email service or electronic service, despite putting his email address on the cover sheet of every UCPR document. In such context, the reason about emphasising strict adherence to rules of the court is that judges are very conscious about ensuring procedural fairness for self-represented litigants, because they want to be seen to be delivering justice and being fair to the extent possible for self-represented parties. In that instance, despite my complaint or submission that there will be no prejudice faced by the self-represented party, the judge who was then assigned to the hearing granted an adjournment of the hearing to allow the self-represented party to put on further evidence. So that's a lesson learned there. The third issue I want to talk about is how to help judges so you can help yourself control the process. I think there are a couple of things that can be done. Firstly, and it's not always easy in the local court and the district court, is to find out as soon as possible the judicial officer who will be presiding the determination of the dispute. Where that judge is known, I think it's helpful to spend a brief period of time going on case law and just finding out the most recent judgments the judge has handed down where there's been a self-represented party. Is a judgment short or is it long? Does the judge fairly deal fairly and comprehensively with all of the arguments raised by the self-represented party, or do they do it in a much more short-handed or summary way? That will give you some, I think, indication of how much patience a judge may have. Of course, things may change on the day, but it's good to get some understanding of previous approaches which the judge may have taken. Second, in our case, we were the respondent on the appeal to the district court. So the self-represented party still had the burden of presenting a court book. I had seen through the evidence which had served that he was going to provide a court book of many volumes, the majority of which was going to be utterly irrelevant. So when the matter was adjourned on the first occasion, the hearing, I sought a direction from the court that we put on a court bundle despite being the respondent/defendant. What I did then with the instructing solicitor was identify what I thought was going to be the essential documents that I would use and that I was reasonably confident would not need to refer to anything else. I compacted that into one folder as opposed to about 8 folders, and then asked the solicitor to put that together and present it to the court. That worked particularly well because I think apart from 1 or 2 what I consider to be irrelevant documents, the judge was able to avoid the inconvenience of having to move from bundle to bundle. He had a folder of documents which had an index which was sorted in a logical order by themes and type of documentation, which was tabulated appropriately and paginated. And I think that really helped the process. I was able to take the judge to the appropriate page or tab references very quickly and without any hesitation. And I think the judge appreciated that. The other thing I would say is getting your written submissions in order and being a bit more detailed to the extent you can. Especially in this COVID environment, I think most judges will tend to read the papers, in my experience, before they come to the bench. Now, I think it's fair to say one advantage we have as legal practitioners is our written submissions will hopefully, I would expect to be more forceful than a self-represented litigant. In my case, it was clear that Judge Taylor had read the submissions and that informed the way he was going to approach the hearing, to which I'll turn now. The judge came on and one of the first things I was thinking about was, do I stand up on my feet, so to speak, and start assisting the court? Or do I stay silent and let the self-represented parties speak? I had thought in my preparation of various permutations about the circumstances in which I would speak and in which I didn't. And this brings me to my theme of staying silent and biting your tongue. When Judge Taylor came onto the bench, he started asking questions straight away of the self-represented party. And I listened very carefully to the way the questions were being asked and tried to understand as quickly as possible what the judge was focusing on. it was apparent the judge was going to take a very interventionist role because he, to me, had already formed a certain view about the case, and he was going to shepherd the self-represented party to what I consider was an outcome that would be favourable for my client. So much of the day, I spent biting my tongue and not saying anything. This may be counterintuitive, especially for advocates in court when your client is sitting in the back or watching you on the video. But sometimes I think there is merit for just staying quiet and let the judge help you. Finally, I think it's sensible to make reasonable concessions in the face of a self-represented party. In our case, the challenge was being made in relation to the cost determination, which had already been reviewed. In the course of my preparation, I identified a couple of mathematical errors which were made against the self-represented party. What we did was, in correspondence prior to the hearing, at the hearing, we made reasonable concessions of those matters. That is helpful because it shows to the judge that this represented party is being reasonable and not taking unfair advantage of the self-represented party, and therefore conferring, in my view, on the judge a degree of trust on the other party. Second, it focuses on the remaining and often poorer and weaker arguments which the self-represented party is seeking to ventilate. By disposing of sensibly what may be considered the stronger arguments, because sometimes there are stronger arguments hidden amongst the plethora of poorer arguments, you're really getting that over and done with, and then leaving the more contentious issues to be dealt with by the judge and self-represented party. Finally, just a couple of words on appeal proofing the case. As in this case, an intention to appeal has been lodged. I think the expectation should be, when facing self-represented parties, is that they will take every step of the way. And I say that principally because they don't have a lot of the cost burdens of paying for legal representation that parties who will face when they're paying solicitors and barristers to assist them. And sometimes they're naive of the cost outcomes that they face until the very end of the litigation. So I think it's important to always approach the first instance proceedings, bearing in mind that there may be an appeal, and therefore crafting your case in a way which ensures that as few appeal points can be taken as possible. I want to leave you with an interesting anecdote about what the self-represented party did. I was expecting, for all accounts, that he will run a German application in the May hearing. And unsurprisingly, he did. At 9:30 a.m. on the morning of the hearing, he sent an email, ex parte, to the judge's associate, complaining of poor computer and telephony equipment, and that he did not believe he will be able to get a fair hearing. The associate replied, copying me, saying it was sufficient for him to appear by telephone. I did not hear further. Next I saw at 10 o'clock, the self-represented and a family member assisting him were appearing by video conference from an empty room in the John Madison Tower, being video conferenced to the judge in his own courtroom, to me in my best spare bedroom, which I'm using for the video conference for the hearing. So what was comforting for me, I'm not sure it's going to happen for anyone else who might be in the district court, seemed like the court called the self-represented person's bluff and then had a way to make sure that the hearing was brought to a head on the day in question. Thank you.
Thank you, Frank. It sounds like you made the best of what could have been a terrible circumstance. Our next speaker is one of our most senior members of the floor, and he's just come off what would have been a difficult ask in the most perfect of circumstances, an 8-week hearing in the equity division before the Chief Judge in Equity. But COVID struck before the hearing concluded. So Simon is here to talk to us about closing submissions to an 8-week hearing in the equity division without oral addresses and the key takeaways. Please welcome Simon Shepherd.
Thanks, Michelle. The first takeaway I had today was this Zoom wouldn't work, and I had trouble getting into the conference, but having gotten over that, we're away. But as Michelle said, I recently experienced this long trial, which started at the beginning of the year, and fortunately we had our evidence finished before the courts were closed as a result of COVID. However, there did remain a significant amount of work to be done for submissions, which had been originally scheduled to take in excess of 10 days for oral submissions. If anything, this experience re-emphasised the importance of submissions, irrespective of whether the hearing is being conducted remotely or not. It drives home that it is your chance to write the judgment. Indeed, many of you will have already noted the increasing habit of judges to ask for word copies of the submissions. And in some respects, this focuses you more on what it is that you want the judge to say or put in their written judgment. The areas I propose to deal with today here are A, different judges, B, the difference in the nature and scope of written submissions only, C, teamwork and preparation, the physical location for remote work, and D, practical questions of physical location for appearances. Just starting up briefly, first of all, with different judges. That makes a significant difference to the mode of operation. Clearly enough, this is always the case, but with an electronic court, the difference is considerably starker. Without naming any judges, I note that the Chief Judge in Equity in Sydney likes to operate with paper only. On the other hand, I'm currently in the commercial list of the Victorian Supreme Court, where the judge there much prefers to work from an electronic court book. In both cases, the court book exceeds 60 volumes of double-sided documents. And where you notice the difference is that, particularly with Zoom hearings, it provides an ability for relevant documents to be put on the screen. So you don't get that situation that often happens, particularly where you've got large court books, where people can't find the documents or there's time to catch up or things like that. And so everybody's got the document at the same time. The difference, the important difference, I suppose, is that in the ordinary course where judges who, I'll call them paper judges, prefer to work with paper documents, you can see them madly scribbling the bits that catch their attention, or they get the highlighter out, or you get a bit of an idea what's happening when you see them working with a court book. On the other hand, when they're working with an electronic court book, other than perhaps making the odd notes, you don't really get the same sense of what's happening. Turning now to the nature and scope of submissions where you have to do them totally in written form as against written and oral. The first point is the nature of the submissions probably doesn't vary as much as the scope. As with all cases, it is invaluable to prepare the submissions early. I'm sure everybody already knows this, but not only does that save on the late nights during the trial and the mad panic at the end of the hearing, but it also provides an invaluable map of the case. The fundamental importance of knowing what evidence is relevant and perhaps more importantly, what evidence will be of no use is clearly exposed when you've written your submissions first and work out what is the evidence that you need to support the submissions you wish to make at the end of the case. Equally, importantly, it assists in cross-examination in identifying what points you will need to get out of a witness, as against generally just point scoring, showing a witness to be a scoundrel and a liar. Often that's entertaining for the client or for various parties, but at the end of the day, it is the submissions focus you on quite simply what are the facts that you need without the danger of getting into other areas. Now, ordinarily, oral submissions in conjunction with written submissions give you an opportunity to set out the substance of your case with the benefit of feedback from the judge. And as most of you will have experienced, that's quite invaluable because there's no doubt you can cover much more ground orally and get a better feeling of where to focus. Sometimes the judge will speak to you and say, look, I'd like you to focus a bit more on this area, or you'll get a feeling that you're wasting time in another area. but important, but probably particularly with long cases where you're not sure which bits need to be highlighted to the judge. In oral submissions, you certainly understand when you're pushing at an open door and you don't need to go further or possibly ruin what's already something that's working in your favour with the judge. And it gives you the chance to spend more time focusing on the parts of your submissions that are going to need work. So the trick is with written submissions, how to make up for this. Now, there's a limit on the amount that can be put in written submissions before you overcome the judge. Sadly, in the case that we just concluded, the submissions ended up being over 500 pages long, but it was a particularly large money laundering case involving nearly 50 defendants and numerous plaintiffs. So sometimes there's just no really short way home. But I suppose with long submissions, it becomes even more important to be really clear about where you're going and to get back to motherhood statements, you know, to deal with the 5 areas that all submissions have to deal with. Being, first of all, you've got to do the introduction, you know, briefly point out what the case is. Now, again, in oral submissions, that's much easier to do because you get a feel of what it is that the judge is on top of and what the judge isn't on top of. Then when you move into the authorities, that again, it's when you're giving oral submissions, it's easy enough to inquire whether the court would be assisted by you taking them through the entire part of a judgment that you wish to quote for your authorities, or alternatively, you'll often from body language realise that you don't need to go through the complete authority. On the other hand, it might be an area of the law or something with which the judge is not entirely comfortable and would be assisted by you going through authorities in some detail and setting them out in full. The only way to deal with that is, if you're unsure, is you've just got to make sure you put in all the relevant parts of the authorities that you think are going to be necessary to your case. Try and cut them down as much as possible, but if in doubt, it's probably better to put more rather than less, because at least in written submissions, the judge can quickly skim through it. Similarly, that leads into the next point, dealing with the evidence. Now, the evidence falls into 2 categories. Clearly, you've got the oral evidence, which is in the transcript, and then you've got documentary evidence. First of all, dealing with oral evidence, the evidence in the transcript. Again, in oral submissions, it's fairly easy to gauge whether or not the judge has remembered the context of the killer point that you are trying to elicit from a particular series of answers given by a witness. In written submissions, you don't know that. So you've just got to be very careful about making sure that you don't get carried away with your own argument and take transcript out of context or put it in such a way that you might be criticised for not contextually setting it up properly. Otherwise, you're going to have twice as much work to do in submissions and reply. The next area of evidence is the documentary evidence. Now, the case that we just finished and the one that I'm just about to start in Victoria by Zoom involves many thousands of documents. Documents in the nature of bank statements, invoices, emails, various agreements. Like all cases, it is necessary to go back to the pleading and make sure you provide the evidence to support the facts alleged in the pleading. And that in itself is a good checklist to work through. But with documentary evidence where you have so many thousands of documents, clearly you don't want, the judge to have a semi-trailer turn up at their chambers providing the documents. So the question is how to shortcut it, but at the same time provide all the information that is necessary for the judge to go through to reach the conclusion you want them to. And for this, I must say I'm a big fan of tables, and using tables to highlight the transaction that you want to do over a certain period, and then working through the invoices, the bank statements, the emails, the agreements, whatever it is you need to match up to make a transaction link, can usually be done quite simply in a table, and with corkbook references on the right-hand side, saves an awful lot of verbiage. The trick in long cases, which involve numerous transactions, hundreds of transactions, is to work out which transactions the judge is on top of. You know, quite often some of the transactions that might be impugned will quite obviously fit the narrative that you want to put in the case. Other transactions might not so be readily identified. And in oral submissions, again, you get the benefit of feedback from the bench, and you can work out which ones need more work and which ones don't. Unfortunately, with written submissions, you've just got to cover them all and make sure that all of the evidence is there that supports the case. You don't get the opportunity, because of a raised eyebrow or a question, to realise that something's missing. And then finally, in relation to applying the authorities to the evidence to get the conclusion you want, this is an area where, if you have set out your submissions properly and thought about them carefully, taking the judge through the evidence, you don't need to waste too much time on it. You need to do it to give the judge a ready reckoner and to make life easier, but it's not something that can quite often end up taking way too many pages. In the words of Mark Twain, I haven't got time to write you a short letter. Take the time to make it short, sharp, and to the point. The final two areas I'd like to briefly comment on are to do with location for preparation of submissions and location for any hearings. First of all, dealing with preparation. One of the things that we discovered from this COVID business was that the use of Zoom conferences is not just useful for courts, but it's also useful for preparing especially long submissions. We had a team of 5 lawyers working on this, and in the past the habit has been for solicitors to come up to the barristers' chambers for conferences, and they have to bring all of the documents and things. And when you've got a case with so many documents, invariably documents get left behind, and there are some difficulties with that often occur. In this instance, we had to get used to people working from their own offices and linking by Zoom. And I must say, for a case of this nature, I actually thought it was better than the traditional way of doing things, in the sense that people have got their documents in their offices. And more importantly, when you're working on a big document, you can put the document on the screen and edit it together. And once you've finished one section, then you can move on without having to revisit it. I think there is a lot to be said for working that way. And it also gives people the ability to dividing work up. It gives a central location for the document. And the real-time editing really does save time in the long run. There's only 2 things that really need careful attention. Don't fall into the trap of different people working on different documents. You do need the discipline of amalgamating the document on a sort of a daily or once every couple of days basis, so that people who have been working on different bits get those bits stuck into one document, so that cross-referencing in the document doesn't become a nightmare later on. And then the final thing is, when so many people have been working on the one document, it's very hard for anyone to proofread it properly. So if possible, get somebody who is not intimate with the case or closely familiar with it, but nevertheless someone who's a lawyer, to read through it at the end, and just to find out where all the typos are. And then the final comments I just wanted to make are in relation to electronic or remote locations for hearings. We have had, after the submissions in this case, because of the nature of the case, we've had some ongoing work to do with it, where we've had to go back before the judge, and indeed with another case that I'm running in Victoria at the moment. And I do note that from the point of view of in-court appearances, it appears to be easier if everybody's in the one room. I mean, I realise that people can use WhatsApp, Skype, text, and in theory work from remote locations. But there are some difficulties with that, whereas the advantages of putting solicitors and counsel together for the electronic hearing is that, you know, pressing the mute button on this thing, it's quite easy for people to converse, and it seems to work more smoothly. But the most important thing of all is to remember to press the mute button. Now, on that note, I think that will finish that. Thank you, Michelle.
Thank you, Simon. We've had a question in from Blake O'Connor to Simon, but I think the circumstances mean it might be more general. Simon, did your case involve the cross-examination of any witness using remote technology, or had you finished that part of the case first?
No, we'd finished that, Blake, by the time the courts got closed. I know some of the other barristers on the floor have had some experience of this, but that's not something I've had to deal with.
Well, what I might do is throw the question open. The question strictly was, how do you deal with cross-examination via video link? Ordinarily, the witness would not be aware of what documents you're taking to them to before cross. Did you have to send a bundle to the witness in advance? Now, I can answer some of that. Whatever's in the court book would be provided by the parties routinely beforehand. But I think the more important or interesting question for those of us doing the cross-examination is, how do we deal with the gotcha documents? What do we do with the ones we want to surprise the witness with? Has anyone who's in on this CPD had to deal with that, to find a way to get the material in real time to the witness?
I can answer that. I think it really comes down to what resources do you have. So I had a case a few years ago where we had witnesses in a number of jurisdictions who the ATO wanted to cross-examine, and the ATO made the video arrangements for those witnesses to appear, and also had a paralegal, I believe, sitting in the room with the witness, and would in real time hand over documents or folders of documents that had been prepared for the purpose of those cross-examinations. But I've also had experiences more recently where it's been necessary just to provide a bundle of documents to the witness because resources don't allow for someone at your own expense to babysit a witness with a bundle of documents. I can't think of a cheap and affordable way of doing it other than asking the witness not to read the documents beforehand, and we all know how effective that's likely to be.
Yeah. Some of the video technology that including the one we're using today, allows us to share a document. Now, leaving aside Evidence Act concerns about how do you get that then tendered, that might be an answer. Katrina, you've just popped up. Have you had to deal with anything like this?
Yes, I was just going to say it wasn't cross-examination. It was just, argument. But the judge said he organised 2 folders, and one folder was documents that, everyone knew what was in there, and another folder was where you could put up a document if you just wanted to show it during the hearing. And I thought that worked really well, and I don't see why it wouldn't work. And that was a Microsoft Teams hearing. I don't see why it wouldn't work for cross-examination.
I think it might. And how many times have we been in the middle of submissions when it's apparent that the judge is incapable of finding the correct page in the bundle, when you just would wish you could throw it up onto a screen and use a pointer without having to repeat 50 times that it's page 7,353, Your Honour, at line D. So maybe there are some things that we can take from this enforced period of different practice when we're all freed up a little bit. Before we let you go, Simon, did you ever get reasons or a sense of why Her Honour didn't want to do the submissions orally by video?
Oh, look, Michelle, I think the trouble was our case had taken so long and so much had banked up behind Her Honour. She was happy to take the opportunity of getting us to do them purely by writing.
Do you think you... Oh, sorry, I didn't mean to cut you off. I was going to say, do you think you actually... Was anything lost in not being able to make oral addresses, even if you had agreed on 2 hours each or something?
I think there's no substitute for oral submissions, to be quite frank. I'm not sure about doing it by Zoom so much, but particularly in court, you know yourself, you can tell when things are going your way, where you need to do more work, whether the judge is getting bored with something or whether the judge is genuinely inquisitive about a particular area that you might want to expand on and things. That
all of the above at the same time.
All that sort of body language and dynamic of a courtroom, it's hard to articulate, but it's real.
Yeah. I did a big mediation recently, and I was talking to someone electronically on the side, and I said it certainly wasn't satisfactory, and I couldn't smell their fear, the other side's fear. Now that was a very flippant way, but you miss that kind of intangible. That's a lot of what skilled advocates read in the room. So that of course would follow into submissions as well. While we've got time and while Blake is still here, Blake, can I ask you what sort of strategic settlement structures could be useful outside of a class action?
Oh, sure. There are plenty. Obviously, paying in tranches, equity instruments and debt, as I mentioned, are some. But I think on the whole, some practical advice would be to get all the relevant actors involved. So that's all the fellow applicants and defendants into one room and sort it out. And that includes related, competing or other proceedings. So an example on this point is ASIC. They've come out recently with their big "Why Not Litigate" strategy. It's a champion of the Deputy Chair, Daniel Crennan. He's been in the press about it a lot. But they often either come behind or before competing civil proceedings. So you'll have a pecuniary penalty proceeding seeking declarations, i.e. directors should be tossed out of the company and penalties should be paid. And you'll have a related proceeding, civil proceeding, seeking compensation for either individuals or groups of people. So I think practically a good settlement structure is one that involves ASIC and the respondents in your case in that example, because it gets all the actors together and solves the issue once and for all. On that point, I note that the corporations legislation was amended last year or the year before so that unsecured creditors and creditors can actually rank ahead of ASIC's pecuniary penalty at any penalty approval stage. So there's a lot of options for leverage to get everyone together in the same room. But settlement structure-wise, I think that's achieved when everyone's together and just being creative, I guess, thinking outside the box.
Thanks, Blake. Does anybody in the group have any additional questions? If you do, you feel free to take yourself off mute and bellow away, or you can use the chat function if you like. No? All right. Well, we're going to have another one of these in 3 weeks. The next one will run at the same time at lunchtime from 1 till 2. Will be on the 24th of June. And we're going to take at viewer request, I hasten to add, we're going to do a little focus on family provision type cases. Some of it will be practical. How do you approach the putting together of an affidavit in accordance with a very complex set of family provision rules, practice notes, and the requirements of the Succession Act. But we're also trying to be a little bit more lighthearted. One of us is going to speak about a recent judgment in which The judge, I'm told Justice Parker of the Supreme Court, got cranky at a self-represented cross-dressing applicant for provision. And certainly I've previously written about assault by oysters as a mainstay of family provision cases. They do seem to throw up the most unusual family circumstances. So family provision on our next CPD on the 24th of June. Do please feel free to ask us to take you off the mailing list if you don't want to be on it, but also feel free, if you do want to be on it, to ask for a particular topic to be covered or make some suggestions. We're always happy to receive them. And can I just conclude by, first of all, thanking all of our speakers. I know they're all busy, and it's really good of them to give us their time on a busy afternoon. But can I also say how good it is to see so many familiar names on the list? And I cannot tell you how much I'm looking forward to seeing some of you in my conference room face to face. But for now, we'll have to deal with a virtual hug from all of you. Thank you again. Good night.
All right.